because we went through all this, we did all our work, which you just heard about, and guess what? We got an award of 5 hours of care per day. Not good. So, team, appeal, the appellants. Let's start with Suzanne. How do we lay the groundwork for the appeal? What's the process?
Okay, first I just want to start off. The only reason why I have any authority to speak up here today about appeals and fair hearings is because of Valerie Bogart, New York LAG, and New York Health Access. I have used New York LAG and New York Health as a Bible to help me understand how to help my clients. And back in 2017, when I was in the trenches and we were losing some major MLTC players and we were dealing with plans not wanting to accept them, I rose my hand to Valerie and I said, I'm having a problem here. Can you help? And with that, Valerie was able to use 2 of my clients and we won transition rights for people coming out of involuntary disenrollments onto the plans. So Valerie, when we do these slides, you have complete authority to say whatever you want, whenever you want, because truly, I am who I am because of what you were able to disseminate to me through your information and your website and through New York LAG. So anyway, it's getting harder to win appeals. I looked back at my history. I've done over 150 appeals starting in 2018. And back in 2018, I was able to win internal appeals 65% of the time. Back in 2019, I was able to win maybe 40% of the time. In 2020, I only won 20% of the time. I'm sure I'm either getting worse at this or something else is going on. And I can honestly say in 2021, I have only won 1 internal appeal. Okay, so what is happening? Next slide, please. I can do it. Hold on one second. So what is happening? So the reason why it's getting hard to win internal appeals is, number one, managed care providers are paid a set rate for enrollees, no matter how much care is needed. So if you need 8 hours, 10 hours, 12 hours, 24-hour split shift, you're losing money for the plan. So there's no incentive to award high-level care. The other reason that I've come to learn and see is Department of Health will consistently not intervene in clinical matters. If I used to complain all the time and the response I would get was, we're not involved in clinical matters, you need to go through the appeal process. Incidentally, Department of Health is wonderful and very, very helpful if protocols not being followed, deadlines are not being followed. So I highly recommend filing complaints to DOH. They will actively get involved in those kind of matters. But anything clinically, they're not going to get involved. The other reason why internal appeals are being lost is members don't have any rights until the first day of enrollment. So you can't do anything until the first day of enrollment. And then on the first day of enrollment, you can ask for an increase. You'll have to wait about 14 days to get a decision, but then the clock starts ticking. So deny, delay, make it difficult, so forth. And then, there is no incentive to do the right thing because, like I said, Department of Health is not going to intervene. So you are going to be forced to exhaust the appeal process. I can tell you, even though I'm doing terribly at the internal appeal level, I have a 99.9% track rate at the external appeal level. So that's something I'm very proud of, but it doesn't speak to me as an advocate. I think it speaks to the policies that are in place that really are in favor.
Suzanne, by external appeal, you mean a fair hearing, correct?
No, I mean, I'm speaking to an external appeal. I like to do external appeals first. The reason being is if you expedited an external appeal, you will get a decision in 72 hours. I will use that as a starting point for my cases. If I, for whatever reason, occasionally I don't win at the external appeal level, then it's on to fair hearing. The disadvantage of a fair hearing is it takes a month to get on the calendar and about a month, if not more, to get a decision. But I can honestly say every time the few times I've only lost 4 externals that I've had to go on to fair hearing, I've won at the fair hearing level. So fair hearing is a great option. It's just a timelier option. And Valerie, if you want to chime in right now.
Okay, well, just to back up, because that's like the next slide. This slide is just backing up. How do you get to that external appeal or fair hearing? So no, just you can stay on that slide here. So the most really critical that a request for an increase has to be put in writing. Like,
Absolutely.
one of the things we see so much is a family comes to us exhausted. They've been caring for mom at night for we've been trying to get an increase for a year, for 2 years. That we say we need it, the nurse nods and says yes. The nurse might even say she agrees they need it, but it's not approved. So people are sort of, lulled into thinking the plan's listening to them and sympathetic, and then nothing happens. And then 6 months goes by and another 6 months. When you request it in writing with the plan, these time limits on the right-hand slide kick in. The plan has 14 days to deny a request for an increase. This is in federal regulations. It can be extended up to 14 days for cause, but they have to give notice. And if that initial request you request that it's be expedited, you have a doctor write that its delay would jeopardize the enrollee's life or health or ability to maintain or regain function. And many times this, if you can't meet that standard, you can't request it. But many of our clients meet that standard. The plan has only 3 days to approve or deny it. But when you do it by phone, if you do it in person, you have no proof that you did it. And then these time limits are harder to hold them to. So if they deny it, they issue something called initial adverse determination, an IAD. It's in this block here. I don't know if you can see my cursor. And so often people call us, I got denied. And we ask them, well, what stage is it at? And they don't know. Can you just go back to the other
sure.
slide?
Sorry about that.
They don't know. You need to know if it's an initial adverse determination or a final adverse, because that tells you what the next step is. Those words are very important. So initial means that the next step is to request a plan appeal. And that's what Suzanne just said, that is much harder to win now. This is this new since 2018 requirement that you have to exhaust your internal appeals with the plan.
Yeah, and Valerie, just to add, a good question just popped up. It says, how do you request an increase? You just put it in writing. A fax letter to the case manager will often just trigger that. And again, this is where Department of Health can be very helpful. If they're not listening, sending proof of a fax, or email to the Department of Health complaint unit saying, I sent a request for an increase. I have not, it's 15 days. I have not heard from the case manager. Here's the proof. It will get things moving. I promise you. I do this all the time.
Explain to the audience to whom the external appeal goes.
Okay, that's it, Peter. That's the next slide. Next slide.
Okay.
This is part 1. All right. First, now let's stay on the other side,
Okay.
because then you get the final adverse determination. You lose the plan appeal. This is the final adverse determination. And again, you can request it to be expedited. Again, the plan has a deadline. Now, when you get the IAD, the initial determination, they have a handy plan appeal request form on that with the fax number. So use that. You don't have to reinvent the wheel and find it. It has the correct fax number to send it to. The FAD will have a fair hearing request form, but it also has this whole pages and pages and pages of information on how to request an external appeal. So now the next slide. And Suzanne, you want, so here you have the option of requesting either, but the beauty is you can do both. And as Suzanne said, fair hearings take so long that what we usually recommend on an increase is request a fair hearing. And when you look at these slides, and also on the big, there's a big information sheet that you have in your materials on rights under the Warshawski class action. Under those rights, you request a fair hearing. You submit proof of homebound status. And again, this is in the materials, that if the client is homebound, 45 days.
Oops.
We have a little bit of a technical
We'll
issue with Valerie.
We'll bump up the, pardon?
We
Valerie,
lost you for a second.
we lost you for about 10 seconds.
Oh,
You're back.
okay.
Thank you.
All right, sorry. I
You
don't.
were saying 45 days.
45 days after you request the hearing, OTDA must order that the plan increase the services to the amount that you requested. It's a temporary relief, sort of like a TRO, under this Warshawski class action. We don't have the time to go through it, but the materials are here, and on your fact sheet, there's a whole fact sheet about Warshawski. Meanwhile, you request the external appeal from the New York State Department of Financial Services. You go to their website. They have a beautiful website. Just Google on their website, external appeals. They make it very easy. They have wonderful forms and templates, but you need to write a very good, strong letter. And I have to thank Suzanne. Suzanne's the one who really told me about this, because Peter, I was like you. I said, what's an external appeal? We've done fair hearings for 30 years. I never heard of them. And Suzanne is the one who told me, she said, hey, you gotta find this out because this is great. So these appeals, they're really designed for regular insurance plans. Like I can appeal my NYLAG insurance plan denial there. But Medicaid recipients can use the system too, because their plans are governed by the insurance law of the state of New York. So it's something under insurance law. It's under state insurance law is the right to the external appeal. And here, if you jump through some extra hoops to have the doctor sign.
Valerie, you're frozen again.
Yeah, so what Valerie's
So
saying, it's important to obtain medical facts and documentation in order to, just don't submit an appeal with a plea to the Department of Financial Services. It's important when it gets to the third party reviewer, you have your medical facts, you have letters of medical necessity, you have IDT discharge summaries that speak to functional assessment, you have in place the facts, so a doctor will review, and like I said, for the most part, 99% of the time, I think it's a very fair process. The few times it hasn't, it goes on to fair hearing, and we get some success. But what I wanted to do for people in the audience is, being in the trenches, I get to hear what families say to me about what happens, like what nurses are saying about managed care. And, there's a lot of fiction and a lot of myth. So it's just very important, before we go to this fun, true and false thing that I'm going to go through you with, it's very important to understand what a managed care company is supposed to do. They're supposed to create a patient-centered care plan. And that's when I advocate, I'm always advocating for that person-centered care plan. So what is a person-centered care plan? The managed care in building a plan is supposed to address the enrollee's skilled, their scheduled and their unscheduled needs, including their personal goals, their strengths, their capacities, their preferences for care. They're supposed to determine if someone needs 24-hour living care, 24-hour split shift care. I have seen probably, like I said, 500 UAS assessments. I have yet to see a UAS assessment address 24-hour needs. And if I had a wish list on reinventing the UAS assessment, I truly wish there was a question that forced that answer, because if they're supposed to develop a person-centered care plan, they're supposed to discuss that. I know when I'm at a UAS assessment, I know I'm discussing it with the nurse and the family. It just never gets documented. And that's a big, and I think that's why the plans get away with what they're getting away with. The last thing a person-centered care plan is supposed to do is discuss what informal supports are out there, who is able to help in the community if they can, and if there's any adaptive special equipment that could be used or supplies that could be used. Okay, I've yet to see a person-centered care plan that fully captures that whole entire scenario. So that being said, I wanted to go through briefly.
Suzanne, let's just let Frank, he has a comment.
Oh,
I
sure,
think.
Frank, I'm sorry.
Yeah. No, you're fine. Can I just ask your opinion on something about this kind of concept that you're talking about here with the patient-centered care plan? So when was the last time roughly that you saw or attended a UAS assessment where there was a nurse in the room with the Medicaid recipient to make that?
Yeah, so the last time was last July, and I was actually shocked because it's still during COVID. One of the plans sent a nurse to the house, but every assessment I have been on since March of last year has been either a phone call or a Zoom call.
And that's kind of my point, because I don't personally understand how a plan can adequately assess someone for 2.5 to 3 hours over the phone when they can't see that person in their home, they can't see how they interact with their family, how they can get in and out of bed, maybe at all, depending if they have the ability to do through a Zoom, because I'm assuming that there are many seniors that don't even have access to technology to show a picture to the assessor. So if we want to talk about why the plan, like maybe why we're seeing some of the trends that we're seeing, I think some of it is the plans just trying to save as many dollars as possible, but there are COVID things here as well.
I can honestly say, having been, because I would go to the assessments with my family, it didn't make a difference me being there and the nurse being in the room. They would watch a potential enrollee walk. Still, I have yet, like I said, I've only once last year was able to get 24-hour care, and I was shocked. I was like, because I just tell my families, we're taking this in stages. Okay. So it's just, again, there's no incentive to give 24-hour care, none whatsoever.
I think we need to pass on, but this is an important point, and I think there are constitutional issues, just as there are in guardianships. These hearings we've been having in the courts for the last year, where the AIP is in a nursing home and his or her counsel can't be present for the hearing to have private conversations, raises the same kind of serious constitutional issues that we've got to address. But we move on. Suzanne,
Yeah,
can you
so
do
let
this
me
quickly?
take-
We've only
take
got
you-
about 6 minutes left.
So we're going to quickly go through this fact or fiction, true or false. Keep note, anyone gets 100, please put it in the chat or the question. I'd love to give you a shout out, but this is what's said in the trenches. So managed care companies are paid a set rate for enrollees regardless of the level of care. True or false? We know that's true. So if you need 24-hour split shift, or you need live-in, or you need 2 hours, the managed care is being paid the same regardless. The managed care company determines if an enrollee is eligible for community-based services. The answer is false. It's the conflict-free assessment again. And this is very important because there has been times when nurses, managed care nurses will say, well, it sounds like your needs are too great and we can't offer you services. That's not true. If the conflict-free assessment is determined you're eligible, you have grounds to fight that, okay? The UAS assessment tasking tool determines hours of care. The answer is false. Again, you're supposed to develop a person-centered care plan, which again is supposed to determine if 24-hour needs exist. So if the nurse at the end of assessment says, I'm going to push my button, I'm going to tell you the amount of hours you are eligible for, That's not true. They really need to look at the big picture. So if a family is, you know, like Betty in this situation, the family would say, well, I've discussed 24 hours of care with you. You need to go on to your supervisor, and we need to discuss this further. It has to go under medical review. It's not just what the tasking tool determines. An individual needs to be bed bound in order to qualify for 24-hour care. I hear this a lot. The answer is false. Regardless if you need limited assistance or you need total dependence, if you need 24-hour care and you meet the qualifying factors, that you should be able to get care. So it's not a bed-bound, bedridden person can only qualify. I cannot tell you how many times I've heard that said at UAS assessments. Valerie, do you want to quickly speak to the live-in split shift?
Suzanne said if you meet the qualifying factors. So these are the qualifying factors. And they're just so specific and clear that you have exactly what the standards are to connect your evidence to show that your client needs assistance with toileting, walking, transferring, turning, or positioning to meet these standards. So this is it. When they give you this nice, clear standard, it's really easy to refute it with good medical evidence.
Okay, family members living in the same home are not required to provide care. True or false? The answer is true. Plans are supposed to ask family their ability to care. They're supposed to, if they are able, there should be a statement of understanding of what that means, but by no means should a family ever feel coerced or forced into providing care for their loved one. And Valerie cited the policies behind that. Technology may be used in place of personal care assistance, true or false? The answer is true, but it must be used safely. So a lot of times I'll see a denial, well, we'll give a person a PERS system, person can't walk by themselves, but how is a PERS going to keep them safely from being able to walk? That's not a safe use of technology. Diapers for toileting instead of personal care assistance, in my opinion, is not a safe use of technology. However, that's what I see a lot of times when plans are issuing their final adverse determinations. Safety and supervision as a standalone task is not covered under managed care. The answer is true, but, and Valerie put in a very important thing, if it's tied to an ADL, it is covered. So again, Betty's discharge planner, whoever wrote that discharge summary, if they wrote 24-hour safety and supervision to ensure safe transfers, toileting, ambulation, we would have something more substantive to fight later for her care for her. But just stating, you know, doctors will sometimes state, you know, person will benefit for 24 hours for safety and supervision. It's not going to cut it at an appeal. We need a little bit more than that. Skilled nursing services are not covered under managed care. The answer is false. There is a private duty nursing program through managed care. I have successfully advocated for 8 people who are receiving 24-hour private duty nursing, people on vents, people with trach care, 24 hours split shift care services. So it is a service important to note, because oftentimes when families have, you know, need nurses, they're told you don't qualify for Medicaid managed care. It's not true. Individuals dementia as their primary diagnosis are not eligible for services. The answer is false. They are. Again, tie it to the ADLs if necessary. You know, Nor broached on the important topic of the NHTD waiver program. It is a program I believe better suited for people with dementia because of the home and community support. They do care about safety and supervision as a standalone task. So I'll often make a dual referral. I'll do the managed care appeal process, but I will also say to my families, let's get the NHTD waiver referral going. And I think that is a better program once you win your awards and your care and you move forward. Lastly, managed care can be more restrictive than fee for service. The answer is false. They cannot be, but having, done NHTD waiver assessments, having done managed care, and having done immediate need with Department of Social Services and HRA, MLTCs are trying to be more restrictive, but they're not allowed to be. And, I can say to you, the appeal process, if we get Betty to the appeal process, her chances of winning are 100% if everything is done for. I have yet to lose a case where I've never gotten what a client needed. I've just gone through obstacle to get there. A lot of help is needed from social workers in the community, rehab, doctors. We're a team. We have to work together, presenting the facts. What I can tell you is the benefits are, once I'm just looking at slides, I'm a little confused here, so I'm just going to go back. Once we get to the external level and we get in front of objective reviewers, the success rate is high. So prevail forward. I mean, Valerie gave me the strength moving when I was a, wee social worker trying to be an advocate. The policies are there. It's worth fighting for.
Thank you
Well,
very much. Suzanne.
you two are the best, and that's why you're here today. Frank, do you just want to wind up? We got maybe a couple minutes and then take some questions.
Sure. Bruce, did you want to chime in for something?
No, I was just going to address the same thing. We have some important slides still coming up, so we might go a little over the hour, but hopefully we can stick with us.
Okay. So because Lou couldn't be here, he wanted to make sure that if we had time that we discussed just a real life case that we had dealt with, because this kind of has a lot of far reaching effects. And it also was put in here to illustrate that sometimes we don't go to hearing just on care decisions and the amount of care that's awarded. Well, I think that's more likely to be most of the fair hearing work that we do going forward. It's not always dealing with that determination. So we had in our office the case of Mrs. S. I'm just trying to see if we can get back to that slide. There we go. So she had to apply for Medicaid. She was in need of a great amount of services. So what we did was we applied for Medicaid down in her local county. And essentially what the county wanted to do was the county wanted to quote unquote, maximize her IRA. Now, if you know anything about IRAs, that's a confusing way of explaining, what they're trying to do. Because when you reach the age of 72 under the current rules, you're allowed to withdraw your entire IRA free of penalty if you wanted to. So when you say you have to maximize your IRA distribution, that could mean you could take the whole thing. Anyway, so essentially what the argument here about was what life expectancy table was going to be used to determine the amount of Mrs. S's RMD distribution. So in our opinion, in the firm's opinion, we should be able to use the least restrictive table. There's a table that's used by the IRS, that's used by most financial offices to determine the amount of someone's RMD. So when we ran the numbers for Mrs. S under that table, she was required to take out $5,000 a month, $5,140 per month. DSS wanted to use a different table, a Social Security table. And essentially the difference between the two is that the life expectancies on the Social Security table are less than an IRS table. So essentially what are we doing? We're taking more money out because we're thinking that she's going to live hypothetically for less of amount of time. So according to DSS, in order for her to be eligible for Medicaid, she was going to have to withdraw over $10,000 per month from her IRA. So the difference on your screen was about $5,400 a month. Now, when we can use something like a pooled trust, which Nadia talked about, right? We can take all the excess income and throw it into a pooled trust. So it doesn't matter whether you have $10,000 a month or $5,000 a month or whatever your excess is, you can shelter it with a pooled trust. But as Nadia also explained during her presentation, one thing we're concerned about when we use pooled trust is when that person passes away, you lose the money in the account. It stays with the charity that runs the pooled trust. So that was kind of our primary concern for Mrs. S, because we were dealing with old rules. But new rules, right? One of the other things that Nadia talked about was if what we think is going to happen with pooled trust that's been rumored is you will have to spend your entire pooled trust deposit every month. How is somebody, the vast majority of Medicaid clients, going to spend $10,000 a month on their care or their other living expenses. Now, we can get creative with a lot of different things. We can take out a mortgage with Frank. We can make sure the aides have the nicest accommodations, but essentially trying to come up with a scenario to spend that amount of money is going to be a very daunting task if that's required. And the other main thing that I wanted to illustrate with this slide is not every county does this. Now, I don't feel comfortable saying which county did this, but not every one county does this. Local counties sometimes will use the IRS table, some will use the Social Security table. So this is an exact point to show that sometimes your determinations for eligibility with your financials really comes down to what county you are applying in. And if you want to talk about why this system doesn't make sense, that's one of the reasons why, because this shouldn't matter what a county you apply in. Every county should do this the same, and here they didn't. We took this case to hearing. We didn't win this case, and it still bothers Lou. So he wanted to just let everyone know that if this happens to you, he's willing to go to hearing on this issue, because we don't think it was correct. We still want to fight this, and it might have some much more far-reaching consequences in the future in 2022 when the new rules are here.
Very interesting. So, Bruce, do we have 5 minutes for a couple of questions before I wind up?
Absolutely. I'll turn it over to Beth. I think she has some questions from the audience. We've been answering a significant number of questions that have come through already. But Beth, are there some questions for the panel?
In fact, I'm seeing that we have, dozens of questions here that we haven't been able to answer live today, but please be assured we'll be doing all that in writing and sending them out to you. Let's see, one question we have on the appeals. Let's see. How do you get someone removed from QMB status in New York City? Is that an MLTC kind of question or appeals?
QMB is not a long-term care benefit. That's qualified Medicare beneficiary. So I think it's sort of off topic.
Okay. How about this
The
one?
Medicare question.
Is the external appeal process available to clients in fee-for-service Medicaid?
No, it's only a process. It's through the Department of Insurance, which in New York State is called the Department of Financial Services, DFS. And it's only about insurance plan coverage. So no, they have the remedy of a fair hearing only in fee-for-service.
Okay. The appeals process is extremely time consuming. How does the advocate team get paid for their time and efforts when the Medicaid recipient or family has no money? I have had to turn people away.
That would be a good use of pooled trust funds if they have it, if they have excess income that's being sheltered. Another avenue of payment could be, in my example, we were talking about Betty having a Medicaid Asset Protection Trust. In any trust that we work on specifically, and in many that I've seen from other offices, there are ways to withdraw funds from Medicaid Asset Protection Trust safely through the lifetime beneficiaries to also free up additional money. Frank's financing options could also be used for that. But if they literally have no money, right, if they literally have $1,000 in the bank account, then obviously that would be a different scenario where it would have to be discussed with the individual attorney on a whether that attorney could take a case like that. But groups like NYLAG and Valerie exist to, partially to assist with people who are low income, low assets, things like that as well.
So let me say there's a statewide network called ICANN. And again, the contact information is on that fact sheet at the end. ICANN is the Independent Consumer Advocacy Network. So it's in every part of the state, and it's state funded to provide assistance navigating MLTC plans, including appeals, except that they cannot do fair hearings. They can counsel people about fair hearings, help them prepare, but they can't actually represent people at fair hearings, thanks to a change in federal regulations made by the Obama administration. But they can do external appeals, which is why a lot of us who are in ICANN have really learned the external appeal process, because it's been a successful alternative to fair hearings. Also, you can use lawhelpny.org. That's LAWHELPNY.org to find free legal services around the state.
It's a fascinating question, and it also is one that comes up often when people need to apply for Social Security disability or they've been denied, that an attorney or any advocate cannot take a fee until the decision is rendered, and then a fee will be awarded out of the retroactive fund. So there is a specialized bar for Social Security matters. Most attorneys won't do it because of the illegality of taking a fee, even if anything related to Social Security. But these are serious questions which impair the rights of people to achieve their legitimate goals.